Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to Serious Privacy, powered by TrustArc. Here are your hosts, Dr. Kay Royal and Paul Breitbart.
When we have a guest, they usually come from Europe or North America, also taking into account the time zones where Kay and I are based. This week, however, we turn our attention down under to talk about what is happening in Australia. And it is a brutal call for Kay at 7 a.m., but we're going to do it. Our guest is John Keeves, partner at Australian law firm Johnson Winter Slattery, based out of Adelaide. And John is a senior corporate lawyer specializing, among other things, in M&A, but also in the follow-up of data breaches, in particular when it comes to responsibility and liability of directors and officers of companies. And he also works on the identification of personal data in unstructured data sets. And he is the co-host of the BLS Report podcast. This is the business law podcast of the Australian Law Council. So I do believe we have enough to talk about today. My name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy. I also have a bit of a cold, everybody. It's not just me being asleep, but I am drinking coffee at the same time. So with that, you know what? I love it. That's where we'll go with the unexpected question is, do you like your coffee black or with cream or with sugar or all three? Or do you even like coffee?
Oh, I definitely love coffee, but I take it as what we call a flat white.
Nice.
Very nice.
Very nice. Paul?
I can do a flat white. For me, it really depends on the mood, but my default choice would be a double espresso.
Oh, I haven't been able to bring myself to do an espresso yet. I'm not sure that would be a pretty sight. My husband brings me coffee in bed every morning. And so our coffee choices go to what's easy for him to make. So at this point, it's hazelnut coffee with a little bit of sugar and a little bit of cream.
Sounds still very sweet to me.
Yes. Well, it probably is because it's hazelnut, right? So, but it's not a frou-frou coffee. I don't do frou-frou coffees. One day I'm going to ask everybody what their default Starbucks order is.
I have none. I tried to avoid Starbucks.
It used to only be my airport thing, and now I still get it other places every now and then. So let's jump into it and talk about Down Under. Where shall we start?
Well, John, I think there is a lot of movement in Australia lately. I think I saw a post from you about new cybersecurity legislation that has been adopted. There is the data protection reform, at least the first part, that has been submitted to Parliament. Can you talk a bit about what is happening in Australia at the moment?
Oh, well, busy time for privacy and cybersecurity. We've got our first sort of, if you like, standalone piece of legislation at a federal level on cybersecurity that was passed just last week. So the Cybersecurity Act of 2024 and also ongoing privacy reforms. So yeah, there's been a lot happening in Australia in this area.
Changes bring, what do companies need to do additionally, especially under the new cybersecurity deal, because that's fixed now. So no more changes to be expected.
Well, at least for the time being, the main thing, well, there's a number of important things in that piece of legislation. One is a ransom payment reporting obligation within 72 hours of paying a ransom, and the government sort of reached a policy position not to outlaw ransom payments, but require reporting so they could be at least tracked. But along with that, there are limited use and limited admissibility provisions, which is important. There's also in that legislation standards for IoT devices, and that's coming in. Obviously, the security around those devices is pretty significant. And then, facilitating provision of information to government in connection with cyber security incidents and the establishment of a cyber incident review board to look at incidents, review them, and fully help people improve. So there's all that, and there's also in the privacy sector, the Privacy and Other Legislation Amendment Bill covered a whole lot of things, but including a new statutory tort for serious invasions of privacy, which is a big move for Australia.
Yeah.
I found the ransomware reporting to be absolutely fascinating. And I wondered if there was thought of having a wall of shame, or do they plan to make these subject to Freedom of Information Acts, or do they plan to keep them quiet when companies report them?
There'll definitely be some dissemination of information within government. I don't believe there's a plan for a public wall of shame, as I think you put it.
Yes.
But it is the whole issue of what is going to be done with the information, within government is obviously a very, very important one. But certainly the policy objective is to assist on a sort of a whole of government, whole of economy basis, keeping track of what's going on and hopefully being in a position where our in particular, our cyber security coordinator, which is a government official tasked with sort of, being in the middle of it all, and the Department of Home Affairs and the AS can be in a position where they can gather intelligence and action it.
So I would guess this requirement to notify government of ransom payments would come on top of any data breach notifications that they would also need to do, or would it be part of the same notification?
No, additional and quite separate. And we were talking just today during a presentation on cybersecurity, and one of my colleagues was pointing out an example where there was quite a significant incursion, but there was no personal information under our regime that actually required a data breach notification. So you could certainly have one without the other, but and they'll potentially happen at different times. But certainly the data breach notification regime is also a very significant piece of regulation for us.
And are any changes on that expected with the new legislative update, or would that more or less stay the same?
I don't think there are sort of significant changes, but there are some changes to provide some additional flexibility in how to handle some of the situation, but not really wholesale change. We've had that sort of notifiable data breach regime for quite some time, so it's not new.
Okay. And that's also something that's being actively enforced. You wrote to us in advance that the Office of the Australian Information Commissioner recently took action against Medibank for a massive data breach. It's not something that we have looked at before. So can you talk a bit about that particular data breach and what's happened there?
Yes. So our Medibank is a private health insurer, and there was a data breach where information relating to 9.7 million policyholders or customers was accessed, and the Office of the Australian Information Commissioner is the regulatory body that is taking action and is seeking civil penalties against the company. And for each contravention, the penalty at the time of the contraventions happened was 2.2 million Australian dollars, which is about 1.4 million US dollars, to put that in context.
Wow.
And the way the regulator has framed the proceedings, one of the ways they're framing it at least is 9.7 million individuals involved, multiplied by the number of days that the contravention was alleged to have occurred, multiplied by the 2.2 million Australian dollars, and you end up with some
massive amount of money.
Right.
Massive amount of money. But the interesting thing is that since that time, the penalties have been increased. It's been the framework's a little bit complicated, but the simple version could be 50 million Australian dollars, which I've got to look at my notes, about 32 million US based on today's exchange rate.
Wow.
So if you do the maths on that, sort of 9.7 million contraventions times 32 million, you end up with some ferociously large numbers. Now, of course, under the doctrines of how you assess penalties for a course of conduct, it's not a simple mathematical exercise, but it's still the likelihood is that there'll be if the allegation's approved, and it's still, it hasn't got to that point yet. But should the allegations be proved, that there is a possibility of a very, very substantial penalty, I think even by kind of other global standards. But we will just have to wait and see. And, we'd certainly expect that to go through, there could be a trial, there could be appeal, could go a long way. But we've also seen in other instances where there have been agreed penalties that have been approved by the court. So we just have to wait and see how it unfolds.
But amounts like that could also easily put an organization out of business. That may also not be the intention of the regulator.
Well, they'd only have to do it once and people would take things pretty seriously.
That's also true.
But I don't think from the point of view of the way an Australian court would approach the determination of penalty that they would likely end up in a point where it would be so significant that it was catastrophic. Having said that, there may be other instances where that could happen. And certainly in other contexts, we've seen instances where penalties have been imposed, not necessarily in terms of data breaches, but in other contexts where they've been significant enough to cause the company to go into an insolvency administration.
Is there any idea how this breach happened? Is it carelessness, recklessness?
Well, look, I do need to be a bit careful because this is an ongoing matter. It's before the courts, and it's there are allegations, and the Medibank has filed a defence and it's contesting certain aspects. But certainly there are elements where that's perhaps some levels of expected security may not have been implemented, or that's what's been alleged. But it's probably better not to go into the finer detail.
Level of decision making that went the wrong direction. Maybe not this one in particular, but in general.
Well, yeah, I'm just don't want to sort of be specific. But what I will say, just as perhaps a slight digression, the regime in Australia in terms of the responsibility of company directors and senior managers who fall into a category of what we call corporate officers under our Corporations Act, there are actually duties of care and diligence, statutory duties of care and diligence that are enforced by our corporate regulator. And it does kind of make Australia a very different jurisdiction to many others when it comes to the responsibility of directors and senior managers. And it is, conceivable, and it has happened that where there has been a failure to exercise reasonable care and diligence, which has inflicted significant harm on a company, that the individual directors have been sued personally and have had civil penalties levied against them and also disqualification orders. And we know that our corporate regulator is when I say looking for opportunities, but we'll take enforcement action in an appropriate situation against individual directors and potentially senior management in relation to a failure to use reasonable care and diligence.
Now, are there criminal penalties associated with this too, John?
Well, yes, there are. Generally speaking, the care and diligence obligation is not one that results in a criminal breach, but there are, there's a range of possible, offences. I guess that by and large, though, our enforcement in relation to, well, certainly privacy is based on civil penalties, and that's, Australia has seen a very significant growth in enforcement by way of civil penalties over the last, I guess, few decades. And partly that is because it's, in a sense, easier to enforce through the civil penalties because it's a civil procedure rather than a criminal one. So, but the penalties, as I mentioned before, can be quite significant in dollar terms. And certainly in the corporate context, there are also potential disqualification orders. So a person can be banned from acting as a director or involved in the management of a corporation, which is a pretty significant sanction too.
Yeah.
Would it be fair to say that Australia has, being an island, also a fairly independent regime when it comes to these kind of breaches, data protection legislation, privacy legislation, breach determination, corporate liability? We see that, especially here in Europe, everybody influences each other. In North America, that happens too. But you seem very much independent also when it comes to the legislation.
To a degree, that's true. I think we are mindful of what other jurisdictions, other countries around the world are doing, but we do have, I guess there's a bit of, what do they call it? Bit of path dependency. We've sort of gone through a number of stages and done our own thing. And so a lot of the measures need to be seen in that context. But I think, some of our regulation, if we sort of go back in history, was based on Britain, but we've sort of certainly diverged and departed in many significant ways. But we definitely look to other jurisdictions for the way they're approaching things. But yeah, we do tend to on some occasions sort of do our own thing. And we do have our own, if you like, political context, which is in some ways, it's similar but different.
Understood. So, Kay, when you compare this to HIPAA and how a similar breach, without going into the specifics of the breach that we discussed, but if an insurance company would have a large data breach that covers so many American citizens, how would that impact also on the liability of corporate officers? Would there be any impact?
There could be impact to corporate officers. HIPAA can hold someone personally liable, and there have been a handful of cases where they've done so. The one that stands out in my head the most, I think, was the first one they did, which was a doctor in Beverly Hills was fined personally. No, he was the first criminal sentence under it. And then the reason why I had asked particular about criminal was also because of the Uber CISO. So not under HIPAA, of course, but the Uber CISO was found criminally guilty. But his sentence was commuted to, I think, 3 years of probation and 200 community service hours and something else that was relatively minor. But that kind of rocked the world to find a CISO guilty. And again, it was not under HIPAA, but it was due to a corporate breach. And for the corporate level of responsibility, they held him guilty under that same premise of, having a duty of care to the people. And so they held him accountable as the executive. And then the wall of shame that I mentioned, John, comes from HIPAA. If you have a breach of 500 or more individuals under HIPAA, there is a public website where these breaches are posted. And so we tend to call that the wall of shame, because you have to report and you can't not go on the wall. You go on the wall if you make a report. So it's interesting how that happens. But I will say that one of the interesting things under HIPAA is that if you have 500 or more, you have to report, immediately. If you have less than 500, you can report them all at the end of the calendar year. I think before like March 1st of the next year or something. And there have been situations where companies have reported multiple small breaches at the same time. But because they were reported at the same time, they were noticed at the same time. And they were also brought under investigation for having 4 or 5 or 6 breaches of the same nature over the course of the year. And then they were also brought forth under investigation. So there's a strategy there. If you have an either or, maybe it's not good to wait to report them all at the same time. But there are criminal violations as well available. So I find it interesting. I was going to ask you, do you think there is something more they should have done with these new cybersecurity regs?
Yes.
Ooh, care to share? Without putting you on the spot there.
Well, I would have liked them to have gone a little bit further and put in place a regime where legally privileged information that was subject to what we call client legal privilege or legal professional privilege, that could be shared with the government on a confidential basis, so as not to give away the privilege, which would encourage sharing certain material with government, which might not otherwise be shared because of concerns about waiver of privilege, and that the material could be used by regulators, but also by class action plaintiffs and so on.
And as attorneys, we care about that.
Well, yeah, and if the policy objective is to encourage people to share information with government, so that can be sort of, if you like, used for the benefit of the broader community. But I just don't think they went far enough. But I think the government and Home Affairs Department probably has a different view, and I think they've gone far enough at this point. But we'll just have to wait and see how the system works in practice over the next few years. One of the changes that was made to the bill on the way through the Parliament was to provide for a review of the legislation after a set period. And I'm sort of hopeful that maybe when that review takes place, that there'll be, another go at solving this problem.
Oh, I like that. Yeah.
So this is sort of playing a long game in law reform.
Yeah.
So would companies in Australia also have the obligation to understand each and every piece of data that they have, to keep registers of processing activities, things like that were introduced in the past couple of years in many modern data protection laws?
I think I should concede at this point that I'm first and foremost a corporate lawyer, and my interest and expertise in the area is at the level of governance. So I don't have a sort of a finely grained understanding of a lot of the stuff that I'm sure you are all across. But from at a practical level, in terms of applying the Australian privacy principles that are in our Privacy Act, if you don't understand the data that you're holding, it seems to me as a matter of principle impossible that you can, comply with your obligations, whether you've got a hardwired obligation to do anything at all. And I think one of my concerns is I think there are plenty of companies, organizations out there that really don't have a good understanding of what they're holding, particularly within unstructured data, particularly, what's sitting on their email server or whatever. And, just by way of example, you've got people, at least I'm aware of plenty of situations where, people are using like a work email account for some of their private communications, and could readily be putting personal information onto an email server or a scan server or whatever, without the organisation really having that visibility. So unless you have the ability to scan and index and really sort of delve into that data, you might find that if you were subject to a breach and someone took away a whole lot of data, you wouldn't have really any idea of what they had.
Saying that unstructured data in particular is very hard to keep track of and to identify, to know what you have and where you have it.
Yeah, that's the unstructured data in particular. But there are tools and methodologies available to find personal information in unstructured data, and so that's, and I think that's from my point of view, I think that's something that people really need to think carefully about, and to be doing the preparation. That's part of the preparation, or whether it's data governance or data cleanliness or whatever. But just we were doing, as I said, we were doing a cybersecurity presentation today with one of our clients, and what we tend to say is, certainly from the point of view of the board and most of their obligations relate to preparation. Being prepared, making sure things are set up well in advance, and when something happens, they're not having to do things in a a disorderly way, and whether it's 90%, 95%, but a lot of the responsibility is that sort of upfront. And I regard that sort of data governance piece as just simply part of that. But one that I don't think is as widely appreciated as perhaps it should be.
And that is probably also true both on the privacy and data protection side, but also on the cybersecurity end. Insufficient awareness, maybe insufficient training, insufficient documentation, and then when something does go wrong, everybody's scrambling and making even more mistakes instead of staying calm and solving the issue.
Yes, and that's why the preparation, and also we definitely counsel doing simulations at various levels and making sure that people are not sort of approaching problems for the first time under that pressure, in the pressure cooker situation. But look, I think for some people this is probably a little bit of an odd thing to say, but the CrowdStrike situation happened some months ago. Obviously wasn't a cyber breach, but it was just what I understand to be some sort of coding error. But I think that a lot of people looked at what happened in that situation, the effect it had on their systems, and it was kind of a bit of a wake up call. But one that, because it, I think a number of organisations sort of thought, wow, we didn't realise exactly how dependent we were on those particular systems and what would happen in terms of interruption to our business processes. Just if we lost just that, and so I think in a weird kind of way, it's been sort of a helpful thing to happen. Which I think a lot of people wouldn't agree with that, but
we do.
We do. It reminds me of a story years ago when I helped a company prepare for GDPR, and they did have an incident that happened in Europe and involving personal phones and personal email and work email and all of this. And before we even woke up over here in the U.S., they had already wiped the phone without doing any type of investigation or forensics. And it was interesting as we worked our way through this, because I was no longer their consultant. I had helped them build the program and left it in their hands. And so they called me up a few months later with this. And then after that, I said, well, and don't forget to do the debrief after the incident. Once you close everything out, make sure you do the debrief. And they contacted me a month later, said, by the way, we closed it out. We did our debrief. And Kay, we did one thing right. I said, what's that? They said, we called you. I said, that is not part of your plan. Nowhere in your plan does it say call Kay. So testing the plan is one thing. Testing the plan for the right things is another.
Yeah. And I think that the point that you make about doing the debrief, that's really important too, from my sort of governance lens on things. Making sure that if there are learnings to be taken from the situation, that they're sort of fed back, and if you like, the same things don't happen again.
Yeah. Well, and I mean, that's the never ending story of Marriott, isn't it? The same thing keeps happening over and over again.
Yep.
And that's why they keep getting in more and more trouble. Hopefully they've solved it now.
Well, it would be helpful indeed if companies that have suffered data breaches in the past will continue to learn, or will actually learn from it to avoid things happening again. We've seen that with multiple companies. Indeed, Marriott was one of them, where issues resurface. I also recall Verizon, I believe, that got in, or Yahoo, that was acquired by Verizon, had all the issues there. John, maybe in wrap up of this episode, we've seen, I think last year, a new information commissioner take office in Australia with Carly Kind. Do you already notice a difference in the way privacy is being discussed in Australia and enforcement, and how scared your clients might be of the OAIC?
I don't think I'd say there's been a step change due to the change in the person holding the position, at least in this instance. I mean, we have seen the OAIC, take enforcement action, but I don't think that can be sort of fully explained just by the change in personnel. And I think over the last few years, there's been, triggered by the Medibank incident. There was also another one involving one of our telecommunications providers, and there've been a number, and it's now something that's got a lot more attention from the point of view of government generally, but also within corporates. I think there are, if we go back a few years, there are a few people who are saying, this is important, but I think there's a general understanding within the business community at a senior level that yep, this is absolutely important, and if it's not in the most important, or the top 3 or 5 things that boards and senior management are thinking about, there's something wrong. So, and I think it will continue to be in that sort of fairly high priority for the foreseeable future. I just can't see anything that's going to change that. But is it as a result of a change in personnel? I don't think it's just that. It's a whole lot of factors.
That's also very fair. Well, thank you very much for joining us tonight in your case, this morning in case of Kate. Appreciate you taking the time to join us from Down Under. And on that note, we'll wrap up another episode of Serious Privacy. If you like the episodes, share with your friends and colleagues. Join the conversation on LinkedIn. You'll find us under Serious Privacy. And also on Blue Sky, you'll find us under seriousprivacy.eu. You'll find me on social media as Paul B and Kay as Heart of Privacy. That's it for this week. Until next week. Goodbye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.